All right, welcome back to the Atomic AMA Matt Chats office hours. It's Wednesday. It's 1 o'clock Eastern, 11 Mountain, and 10 a.m. Pacific. And we're here to decode the matters of wealth, one insightful conversation at a time with my good friend, Matt Meuli. And the purpose of this is so that you can not only grow and protect your net worth, but also your net happiness. And these are where we go deep on your questions, not ours, unpacking the articles, unpacking the things we're writing about on Shields and Succession so that you get a chance to have more clarity into the decisions that you need to make. So as always, I'm here. I'm Chris Snook, and I'm here with Matt. Matt, welcome back to another Matt Chats.
Hey, thank you, Chris. It's nice to be here. Always nice to talk about these issues and see how we can help.
Awesome. Well, and I'm going to do the disclaimer because I always forget, and then you always do a good job. So the disclaimer is Matt is an attorney. He's been licensed in 2 states for more than 30-ish years, we'll say. He's a young man. And but he's not yet your attorney. So everything that you hear today could be applicable into the conversations you may want to have. If you need counsel, we'll talk about where and who you can call to get a conversation or a pre-consult. But for right now, for this purpose, this is not legal advice, should not be construed as legal tax, financial advice in any way, shape, or form. But it definitely are, and definitely is, rather, the questions and the conversation starters and nuances that you should be thinking about, should be talking to your counsel, your advisors, your fiduciaries, and your family, most importantly, about. So with that, I let Matt clean up that disclaimer any way he sees fit, and we'll get right into it.
Yeah, no, I appreciate that. Yeah, just these are more of my opinions and the things I would do. And as we've been doing these Matt chats, we've been getting deeper and deeper into the subject, and a lot of it has gotten to what we call elder law in the trade. And you know, our practice, a lot of things that we do is designed to avoid what where we're getting to these questions. We try to avoid these things from happening. We're trying usually to do it on the front end where we're doing a lot of more pre-planning instead of the crisis planning, which always happens after an incapacitating event or something like that. So a lot of the people come in and ask us these questions that we're looking at from our viewers. We end up actually referring those out to someone who has more experience because we don't always get to answer these questions because of the preventative measures that we've taken with the trust writing and things like that. So, today may even be more of, what I would do as an individual or my opinion type of thing, or how I would treat my family and those kind of things rather than legal advice.
Yeah, and I think it's a good point. So again, an ounce of prevention is worth a pound of cure, as the old saying goes, and we're in the prevention business. That's why we do these weekly. That's why we write the articles we do, and then we answer the questions that you guys submit. So please keep those comments, keep those questions, keep the dialogue coming because it helps us personalize this. There's a lot of ways to prevent a lot of this stuff. There is also nothing like pain as a teacher. And so unfortunately, some of the questions, some of the comments that come in are people that are in the thick of it, or maybe just on the other side of that crisis. And we thank you for those because that's something that other people can learn from. The point is the real risk, as I say, is doing nothing. And we live in a time where we are putting these conversations out there as much as we are, so that we're empowering people more to understand where they are in that cycle. If you want and need help, if you're not sure, and you are trying to be on the preventative side of it, or kind of in that mode, then Colorado residents can dial 970-820-0090. Residents from all 50 states that want to talk to us about some of the Wyoming asset protection strategies, some of the trust stuff there, can dial 307-463-3600. You'll talk to a human. If it's not something that Matt's practices or one of our practices does, like he said, we're happy to kind of rapidly and efficiently direct traffic to maybe a referral source or trusted planner that you could work with. But again, let's talk about this through the lens of what they could do. Let's talk about how you would handle it if it was your family and opinion, because again, that's valuable in its own right. And we'll just get into it. So we're going to talk about the 10 audience questions that were submitted off of our latest Shield and Succession article. This one was really more about the predators that arrive before death. We talked about this in different ways over the last couple of weeks, but last week we put out a piece that was very specific about that. And so there was some follow-up. So I'm just going to go right down the list. So the first question was, what are the warning signs of elder financial abuse before a parent is legally incapacitated? What are some of the phrases, word strings, whatever it is that would let me know, something might be going on with mom or dad's. Like they might be feeling some stuff.
Yeah, and that's a great question because how do you find this stuff out? I mean, how do you know? Because a lot of times if someone is susceptible or has fallen for a scam or something like that, and they realize it, they feel pretty self conscious about that, and just almost to the point where they're going to hide it. They're not going to tell you about it because they're just like embarrassed, basically, and so it's very difficult to find these things. And a lot of the ways that we find people track these things is just, what is actually happening to the accounts or the finances themselves, because it's really not a warning sign other than you normally see with parents. Short-term memory goes first a lot of times, and they can't remember, what happened yesterday, but they can tell you about their childhood way, way long ago. And a lot of that comes when you look at the science behind that. It's just that long-term memory, when they had this experience, that was the experience that shaped that feeling that they're having. So they're telling you how they feel by using these way past references, but they're losing the things right in front of them, and so they're thinking in old pictures, basically. And so that's one of the signs.
Mhm.
You just don't have a recollection of what's happening now. You don't know what season of the year it is. If you're given 3 objects, you can't repeat those later on and things like that. You're just starting to get that decline. But most people kind of blow that off. I mean, they are your family, and you're trying to be loving and all those kind of things. So a lot of things you notice is something that happened with the finances, and what can happen as long as you have access to those, you can see some warning sign. And one of those is just unexplained withdrawals. I mean, why is this money coming out of the account? Sometimes we see there's a new person on the joint bank account that you don't know, or whatever, that's a sign that's happening. Um, Another one, maybe you don't have that, but you're starting to hear complaints about creditors because things are going unpaid, even though there's supposed to be money and everything like that. So maybe the money's being redirected, or something like that. Abrupt changes to a power of attorney. All of a sudden there's a new agent in town. Um, Missing property. Things in the home are no longer there. The jewelry and things like that are disappearing after the caregiver comes, or the cleaning person, or whatever. These are just all signs that you can see in there. And then it gets even more extreme where, there's new companions that move in, or people that try to isolate the parent from the kids. They take away their phone and things like that and say, well, the reason why you don't get phone calls is your kids no longer care for you, kind of ingratiating themselves into their lives. So those are all signs. There's not really a red flag, but like I said, the easiest in my experience, has been that people notice that something's missing, money, monetarily or personal property.
Yeah, and I think some of the other things too are if we go down a rung to kind of still very active, call it parents in the age bracket of 70 to 75, but where they're still highly functioning, still maybe both healthy, all those kind of things. What are some of the the slippery patterns that you can see where it could become overwhelming, meaning like slowly then suddenly it becomes a thing. It's not a thing today. It could be that one parent more than both is taking on more and more responsibility just to get through the day, whether it's, no more passwords are owned by or accessed by the one parent or the one spouse. If somebody starts taking on a bigger burden of just the day to day, that's not a warning sign per se, in my opinion. Maybe you agree, but it is a signal. It is a signal that at some point that could become a load that's heavier to carry, simply because um, it's a wear and tear just on on their mental sugars, right? Like it's more to manage if it's not a dual effort anymore. So just some things to kind of maybe spark a conversation in advance is what I'm getting at.
Well, yeah, I
You
mean,
agree?
the caregiver always is going to be. There's a lot more effort to take care of someone usually than it is to be taken care of, and so you can actually watch them caregiver age, before your eyes because of the additional stress and trying to do everything and make all the decisions and whatnot. And sometimes there's a more dominant partner that needs to not be writing checks or whatever, but the other partner does not want to tell them or stop that because they feel it's going to ruin the relationship, and you can see that stress happening as well. And but then, it's just, with his additional, duties that the one spouse, the caregiver spouse is trying to take on, that's when you just start getting some unexplained activity that you just weren't seeing before, missed appointments, a lot of, ATM withdrawals, you need a lot of money, missing statements, maybe the bank statements are no longer coming to the house, well, where are they going kind of thing. But there's unpaid obligations like I talked about. There's just some things that, you can look for. But easiest, when a lot of times people want the proof, because they're just like, are my parents really losing it, or is just me? The proof is usually something financial or something missing that kind of lets you know that something's amiss. Or sometimes they stop doing things, they stop doing activities because the one spouse can't get the other one out and about like they used to, and have the friends and the friendships like they used to. They're no longer playing golf, or they're no longer going on playing bridge or something like that. But again, it all boils down to a lot of these things we've been talking about, Chris, is just what you and I are doing is talking about them. I mean, as a child of something going on, it's good to stop over once in a while and check on, try to have conversations to find out things are going, and make sure you're not accusing anybody and saying, well, you're losing money. How could you possibly do this? Or you need to tell somebody, mom, that you need care, or you've recently broken something because you were trying to lift dad, and you weren't strong enough, so you've fallen and broken a hip and things like that. So you just really need to keep contact with them during those latter years so you can start seeing the warning signs and just, get in a place where you can help.
So this is a two-part question. I'm going to start in one at a time. I'm not going to throw both at you. We talked about this in one of the weekly episodes. I can't remember. We've written about it a couple different ways, but not everybody sees every piece, right? So this question came in off this last one, and then it builds into the second one. So the first part is just what happens if someone becomes incapacitated and there isn't a power of attorney in place, either a medical power attorney or a financial one. They didn't clarify that, but we talked about you really should have two. If there isn't one in place, remind everybody what kind of normally happens. I know it's state by state, but what normally happens?
Well, normally you need to go, get someone who has the right to take care of that person. And that usually goes through some kind of proceeding where you're taking away the rights from that person and giving into someone else. And that's usually through a court process. And in a lot of states, it's part of the probate process where you're going to take away those rights. And there's two things, that you're doing. You basically go to court. Sometimes it can be an emergency type of thing where you can get in the court quicker than other things. But the idea is there's some sort of proceeding. Sometimes it's called a guardianship proceeding. And the guardian is the one who kind of does the medical records and makes sure of the well-being of the physical person and things like that. And then there's a proceeding called a conservator or a conservatorship proceeding, and that is for the finances. That's the one who pays the bills and takes care of the finances. So there's kind of these two separate proceedings that you can do. You can ask for both of them at the same time, and the same person can do both. But the law really does separate those two things. For example, when you do have capacity and you can sign a document, we call those powers of attorney, and one's usually a financial power of attorney, and the other one's a medical power of attorney. So we do split those up legally, even when you have capacity, because maybe the person who pays the bills isn't the best one to make the decisions for you medically. So that's the way it is. But if you don't have those and you no longer have capacity, you can't sign a new one. So you need to go to a court proceeding called a conservatorship or guardianship proceeding. Typically in those, there'll be a judge, there will be a guardian ad litem, which is someone who protects the person who's losing their rights. We call that the ward. This guardian ad litem, make sure that they raise issues and, raise the legal defense for the ward so that, someone's not just taking over, someone's not just coming in and taking rights. And then there's usually a visitor that's appointed by the court, which is a person who goes either to the skilled nursing care facility or at home or whatever, but their job is to certify that the person is going to be taken care of. They're in a clean place. They have the right medical persons. They may need a lift if there's someone that they have to lift them in and out of bed, but they're the person who ensures to the court that this person is going to be taken care of. And all these people get paid by the person bringing the proceedings trying to get the guardianship or the conservatorship. We need to pay the guardian ad litem, the attorney doing that, and a lot of times it's an attorney that's appointed to be the visitor or some other court personnel. So we end up paying all those just and the attorney to bring the action to begin with. So that's why it can get real expensive, and that's why we really focus on the preventative side of this because the preventative side is always usually better and a lot. Uh,
Yeah, because I can speak from one personal experience that was in the family. There was this person way into their 90s, was very, very high capacity, all the way up until maybe 94, 95, and driving all those things. Mentally sharp, like the epitome of, hey, had a good long run, right? Like that kind of thing. And then it hit kind of a point where all of a sudden the capacity of that mental side started to go downhill pretty rapidly, like in a mirror, and it started to show up with phone calls um, to the child who was not me, but was phone calls in the, and it was like, I went to the bank today. How'd you go to the bank? We got rid of your car 6 months ago. Well, I knocked on the neighbor's door and I told him I needed a ride. Why did you need a ride? Because I had to go get $10,000 out of the bank. Why did you need to go get $10,000 out of the bank? Right. And, well, I don't remember, but then I got to the bank and then I couldn't remember. And then this situation, there was financial power of attorney. There was some power of attorney around the financial stuff. Right. So there was like, I couldn't get my money. So the call was actually one of anger. I couldn't get my money. They wouldn't let me have my $10,000. Right.
right.
I don't believe, and I can't recall, but I think because of the process, there wasn't a medical power of attorney in place. And so because this was kind of a mental capacity issue, essentially similar process of what you just mentioned, there was like a hearing. There had to be kind of a hearing to, essentially have a third party intervene and say, I either will or won't take this person's rights away. And I have to evaluate it. And there's all kinds of things there, which is now that person is standing in front of a public court and has to admit that they are failing. Like in other words, there's all these other knock-on effects emotionally that could happen. It's not easy either way,
Mhm.
but I think because again, you're either having the conversation in private and it's tough and it's resisted, or the person's now at that point where you actually need to protect them from their own self or from her, from whatever. It's never easy, but it's easier to do it in advance.
Well,
That's,
yeah,
I think, the point.
yeah, a lot easier to invest. I mean, the other people that are there at that hearing are sometimes they're the doctors or psychologists that are just, testifying in front of this person that they don't have capacity to take care of themselves. Um, and, typically when we're doing it with people on a proactive basis, we're only talking about the right to, financial capabilities and things like that. We're not talking about the whole person and, you can't vote anymore, you can't drive, you can't do anything because the judge is going to take that away. And that's, that can lead to resentment and things like that. So, when we do it ahead of time, we even ask the person, what's acceptable to you to show that you're incapacitated. Some people will say, hey, I really trust my kids. And I got two of them, and if they unanimously say that I should not be writing checks anymore, I should not be my own trustee, that's good enough for me. And, now you're talking to kids and they do that. And then you have a legal way to go to the banks and, stop this from happening and things like that. So that's why that proactive works so well, because if you don't have that, you're trying to figure out what the definition in your state is of incapacity and trying to prove that. And is it a doctor or is it two doctors or what does the statute say? And how you going to show this? And then you're actually litigating it. And, you have an attorney who's been appointed to over the ward whose, sole purpose is to make sure that it's appropriate. So they're going to be challenging everything that your doctors are saying and maybe imputing what they're saying, which is now it's a hassle and it's just, these guys are getting paid hourly and they're making this case a lot longer and that can happen.
So on the second piece of that, so there is a process. Again, it's not going to be one you maybe like, but there is a process for if someone becomes incapacitated and a power of attorney, financial or medical or both, was not in place. There's a process for that. Sometimes it can be expedited. It means the courts are involved, and You just kind of went through that in detail. Now, the other side of that is this was a good, go ahead.
When they're expedited like that, that usually means it's like a temporary type of an arrangement, because it needs to be fast. And the trade-off for not giving like a full hearing to take away these rights is it's just going to be maybe 90 days or something like that. And
Mm,
it's an emergency situation. So you got that temporary, but then you have to reissue it for permanent ones. So sometimes you need to go into the case twice because, you get the temporary and then that, and basically the temporary, the ward doesn't get as much ability to push back against the appointment. That their rights
right.
aren't solidly protected because the downside isn't as big. We're just trying to take care of this person for a short period of time, and if they're better in 90 days, we don't need to go forward. But if they're not, then we need to turn those into permanent. So that you almost have two whacks at it. That just to be able
Right.
to kind of a public situation and get berated. You can't make these decisions anymore.
Yeah,
Uh,
got it. Well, that's a that's a good thing to add into that because I think again, one more reason why if you can get in front of it, it's better. So this was a good question because we talked about this at length and we mentioned power of attorneys at length. The question came in: can someone with a power of attorney transfer money to themselves, change beneficiaries, or make gifts? And if so, what guardrails can you put in place to prevent someone from having a power of attorney that could just go wild? Because that's another form of essentially confiscation potentially if the wrong person has the power of attorney.
Right. Yeah. And so, yeah, and it depends on the power of attorney and what the power of attorney says, because what a power of attorney does is it basically has a principal, which is a person who has all the powers and they're giving it to some other person, which we call an agent. And your power of attorney can be limited or it can be full or, there's a bunch of different ways, but you can choose while you're competent, you can choose which powers you want to give to your agent. For example, if you just want that agent to be able to sell your house, you're only going to give them the real estate powers. You're not going to give them the powers to, you know, uh, turn off your bank accounts, turn off your utilities, change your beneficiaries on your life insurance and your IRAs and all those kind of things. So those are called limited or special powers of attorney, special limited powers of attorney in a lot of states. So that's the first thing, is just what power do you give them? And so you really need to look at the document first to see what kind of powers you have. Uh, Using the principal's money to benefit yourself, we call that self dealing a lot of times. And some powers of attorney allow that. Some powers of attorney say you can compensate yourself for being powers of attorney. A lot of times you got to do that, especially if you have a professional power of attorney, because they're going to want to get paid for doing this because it's not a lot of fun paying other people's bills and making all these decisions at times. So, uh, absolutely, if the power of attorney just gives a blanket uh, gift of all your powers, your agent can pretty much run amok um, doing things for you. Now, if the uh, principal, the person who signs the powers, if they're have capacity, they can revoke these things. But they have to let the bank or whoever's the agent using, they got to let them know that it's been revoked. Otherwise, they have the paper, they have the power. But if they're not, um, they don't have capacity. It's more difficult to revoke these things. So, the second part of that is if you do if you do have someone who needs help like this, and you approach them and you're saying, "Hey, I want to help. I want to make this work as easy as we can." You can put some safeguards on some of the accounts. I mean, you need the account owner's permission, but you can go to the brokerage firms and things like that, and you can ask to put a trusted contact in there, so that the broker knows that if any time that there's these big withdrawals or we're changing beneficiaries and things like that, that they need to talk to the trusted contact. Putting the trusted contact there gives the broker the right and ability to talk to the trusted contact to see, if this is, are we violating this this elder's rights by giving away their money, things like that. And then you can go in and set, scam alerts and things like that on the accounts and things like that. If a certain amount of money gets deposited or taken out, that you're immediately notified, so you can hopefully see that when you have the principal's permission, sometimes you can go and freeze their credit, with the big three agencies so that no one can start getting credit in their name or apply for loans and things like that.
Which I can tell you, once you freeze it, even if you want to unfreeze it, it's like the most impossible task ever because Experian doesn't have a phone number that answers. So, if you can get it frozen, it's probably going to be an act of God to get it unfrozen, even if you wanted to. So that's a good thing, I guess. If if mom and dad aren't going to be getting more lines of credit anytime soon.
Right. If this is happy, if it's happening, yeah. And incidentally, sometimes when we do a lot of trust and trust administration and probate administration, and the problem with those two things is that the reason why we're administering is because someone's passed away, and sometimes it's just a good idea if someone's passed away is to go ahead and let these credit bureaus know that, so that someone can get a hold of the social security number and start taking out credit in a deceased person's name, because that's hard to discover as well. So those are just
Yeah.
things you can do. Like,
So,
uh,
well, on this topic, keep going. But on this topic, just weave in. This was a clarifying question someone asked. Difference between guardianship, conservatorship, and a power of attorney, and when a family would pursue using maybe guardianship or conservatorship instead of just relying on the power of attorney.
okay, well, yeah. So to get the power of attorney, and again, the power of attorney is giving the powers you want to your agent. It's kind of like someone explained it to me once. It's like a string of Christmas lights. Each color is a different power that you have, but they're all hooked to the string there, and it's plugged into you. That's how they get the power. So if you don't want them to have certain powers, you take out all the red ones or the blue ones or whatever. You just give them the power you want, but it's got to be plugged into you for them to get that power. So when you pass away, your power of attorney no longer works because it doesn't have the power, and that's. But if you're incapacitated, you can't plug it in either. You can only use the one that you have, because once you do not have capacity, you can no longer sign for yourself to give away these powers. Yeah, three things you need to get a power of attorney working, and you need to be alive, you need to have capacity, and then you need to be able to sign something. And if you don't have all those three things, you ain't getting another power of attorney. And on the power of attorney thing, it's either medical or it's financial. Sometimes it's called a financial durable power of attorney. The durable just means it survives your incapacity. It doesn't mean it survives your death. Again, it's turned off
Mm.
when, but that's what you have. So the medical power of attorney is what takes care of you with the doctors. It usually has a Health Insurance Portability and Accountability Act, a HIPAA release in there, allowing you to talk to the doctors, which is real important, because if you can't talk to the doctors, but you have to make the health decisions, that puts you in a pretty big bind. Um, and the medical power of attorney, you don't necessarily have to be incapacitated for it to work. You just could be unconscious. You could be, in surgery and they got to go a different direction. They need someone's permission or things like that. So that one's kind of being used and not used. So you're kind of, it goes in effect, comes out of effect, goes in effect, comes out of effect, which a financial power of attorney can do as well. But typically, once you have a mental decline, you don't like recover. If you do, you can revoke it, whatever. But that's the idea. So you have the medical one to take care of the person, and then you have the financial one to take care of the estate or the money, basically. And so you typically those two powers of attorney do not cross over. They're separate for each one of those. And so if you don't have those three things going for you, where you're alive, you can sign, you have capacity, you then need the only way you can give your power to someone is by them taking it through those conservatorship or guardianship proceedings. And the conservatorship is for the estate or the finances, and the guardianship is the one like the medical power of attorney. It's more akin to taking care of the person and their medical needs. So, and they can be different people as well. But, a lot of times it's just, your kids are taking that over or something like that.
Gotcha. All right. So shifting gears, these are two different questions, but they interrelate. So let's start with the first one. So what are the steps I should take, or what should I do if I suspect that a caregiver, family member, financial advisor, somebody is stealing from me or my loved one? What are like the practical steps? Do I call the cops? I think that's what they're asking. So let's just start there. Like, you have a suspicion. What's your opinion on what the right order of actions would be?
Yeah, I mean that's difficult. That's something that I don't have a lot of experience with. But typically with the people I talk to, I mean there are steps that you can take. Normally in the state there is an Adult Protective Services, like APS, by different names and whatnot. And they're actually the primary agency in the state that investigates these allegations, of either abuse or neglect or exploitation, if you will, taking of the money and those kind of things. So that's one of the things you can do. And they're and when you call them, they have like resources and hotlines and things like that that they can help you direct you to other places. If you know that if you're person that is being exploited, if they only have one bank, you might talk to the bank, and tell them what's going on. If you can, sometimes when you just report suspicious exploitation or suspicious, financial abuse to bank, the state may have a law that says that they're empowered to pause bank transactions until they report it to someone else. And sometimes I've received calls from some of my clients, financial institutions, saying, "Hey, this person's doing this person's doing this. Are they okay? Um, you know, can we make this withdrawal? I mean, have you met with them lately?" They're asking us because they're bound by, depending what state they're in, they're bound by certain laws that say they pause once they have noticed that there could be abuse there. Then, like you said, you can file a police report, that with the police or the sheriff's office, that, you can start an investigation. But another thing, is maybe secure the assets, if it's a family member or a caregiver that has power of attorney, work with an elder law attorney or something to freeze that or revoke it or freeze the accounts to prevent that actor or that agent from doing continual stuff. But you're getting into like a litigation type of thing because you got your side and the other side, and so during all this, you got to keep in your mind that you probably need to document this however you can, by collecting evidence or whatever, bank statements or ATM receipts or whatever you have out there, that canceled checks and those kind of things that are kind of showing that these bad.
And I want to be very clear. Litigation is not something that you or your firm specializes in, and and so what would be likely the case is you would have kind of a list of these things that you've prepared, have in place to prevent these kind of things when there's suspicion. What I hear you saying, which makes sense, is you just start to try and document a timeline. When did I first have that suspicion? What was the signal? Whether it was a bank statement, whether it was a weird phone call or an email or something that didn't make sense. Start to document that, start to put it into a place, and then probably look into like you said, whatever the version of APS in my area might be. B, if I feel like it's not something that is contained, or if it's happening to me or if it's happening to my loved one that ultimately I might be the administrator for, if I can't get down to it with one conversation, it might be time to reach out to someone who specializes in litigation for these kind of crimes, basically, and go from there. So let's shift gears back to the things that you do, and we'll try to answer that on the best we could. And thanks for submitting them. We'll tell you when we don't have the best answer, who you should call. But I think everybody can kind of understand, at least that's something practical that would help them before they just start calling litigation attorneys and ringing up bills. Build your timeline, right? Start to build a timeline and have a conversation and then decide from there. So, all right. So let's talk about it. Most of the audience that tunes in or reads our stuff is, somewhere between $2 to $30 million in net worth. They're high net worth families. They may have earned that through a small business. They may have just invested in dollar cost averaged over the last 15, 20, 30 years in the markets, whatever it is. So they have something significant to lose. They may or may not consider themselves to be a very sophisticated family office. We have those clients too, or those readers too. But for that sweet spot of kind of like a wealthy family with something to lose that has probably got more than one bank account, probably more than one entity, or should, let's talk about some of these answers through that lens. What are some of the things that when you're doing the trust administration for someone, right? Like, let's say that they're a $5 million, $3 to $5 million family. Maybe they have a Wyoming asset protection trust, or looking into it, or they have some kind of structure like that to kind of have irrevocable shelters for certain assets, and then they have their revocable trust and their will and their stuff in design with their state for the things that they need to be able to move in and out of. How do they know or recognize or put who do they trust as the fiduciaries? And then how do they kind of keep those people honest? Because a lot of times, especially the older generation, they may have had this person for 15, 20, 30 years. And so they kind of just have that momentum.
Mhm.
But as we all know, things happen to all of us. Everyone is human. And just because they've done right by us for 15, 20 years doesn't mean something couldn't change in their situation that puts undue pressure and brings out a side of them that we didn't see. And so that's usually, something that's harder to see, even harder to deal with because it feels like betrayal. What are some of the practices or the checks and balances that you put in place as someone who administers these things? And like, what are some of the lessons learned there?
Well, yeah, on a revocable trust, the way that we write those, and revocable just simply means that there's not really any asset protection. You can revoke it and do all these other things. And typically, a revocable trust is used to take care of you during incapacity and help you avoid probate at whatever your state level is. Um, but having the people identified ahead of time is the key. What makes a good trustee, what makes bad trustee, those kind of things. Uh, Typically, in those trusts, there's a fiduciary duty, which is a high standard of care and how you need to pursue your duty. And a trustee's duty is to benefit the beneficiaries. And a lot of times, if you have a different trustee from beneficiaries, you have little checks and balances because the beneficiary can complain to the trustee or the courts or whoever if uh, they see that the trustee is depleting their inheritance, basically, contrary to what the trust says. And the reason why we like trust better than these powers of attorney things is that a trust can be a lot more robust and have like instructions to, along with the fact that, I can go get money out of a bank account for this person as a successor trustee. And I can do this with the life insurance and those kind of things. But then the trust will go further and say, yes, I can access this thing, these funds, but I have to spend them on the following things, or I have to take care of the following things. And there's more of an instructions in the trust typically than there are in a power of attorney, where the power of attorney just says, you have the right. You have the right to my bank accounts. You have the right to change the beneficiary on my IRAs and things like that. But it doesn't have instructions to go there. So just having a trust in place a lot of times will help a lot of those things that we're mentioning as far as people being able to take abuse. It'll help those keep from happening. Um,
How about processes around, like, let's say that the principal person who creates the asset protection trust. Let's assume there's an irrevocable trust in the mix, just for this example, and let's say that is invested, right? Or I'm assuming that these monies are there, or these assets are there, and they're continuing to appreciate it. They're designed to. Um, and so they're managed by somebody, whoever that fiduciary may be, right? Whether it's an RIA, whether it's a broker dealer, whether it's somebody else. And the person who's the principal is doing that, and they've kind of helped create the rules. The other person, it could be a spouse, it could be a new spouse, it could be, a second spouse, whatever it may be, comes into the mix. The irrevocability of that trust has a certain level of protection, but there's also this side of essentially, um, this other party now has an opinion. Maybe they have their own advisors. Maybe they have somebody that's watching out for them. And so assume that it's amicable, but there's a change of control request, meaning I want you to use some of my people, or I want you. What are the things that you suggest people consider writing in, almost like in a business agreement? You'd have a buy-sell agreement up front to try and mitigate some questions down the road when everyone's not happy anymore. What are the kind of things that you see working well with those structures on asset protection or not? Are they post nups? What are they that typically work the best as far as least friction, but also most control and flexibility at the same time?
okay, yeah. So an irrevocable trust basically is one that, is not as easy to revoke as a revocable trust. I mean, that's the main difference. And a lot of when you talk about asset protection and things like that, the irrevocability is what helps. At matter of fact, a revocable trust has a chance to turn irrevocable and does turn irrevocable when the person who wrote it, which we call the grantor or settler, dies. So, a lot of trusts turn irrevocable over time. And then that just means they're harder to amend, they're harder to change, and not impossible, but harder. And so that's the idea that when a trust either starts out irrevocable or becomes irrevocable, you have to have things in the trust that allow for these contingencies and a little bit of flexibility where you can, where you don't want to maybe let creditors and other people reach the principle of the trust. You may want to let beneficiaries have the right to change a trustee or change a manager. And we get real concerned when we see trusts that have somebody written in as a manager, who's 70 years old, is going to retire next couple of years, but they're in this irrevocable trust as who's going to be managing the trust, or either as the distribution trustee, which is the person who signs the check, or as the administrative trustee, which is the person who administers the trust. So having that flexibility, working with someone who has the flexibility to, know that that can happen and then have it actually written into the document will help change those things. And sometimes you can give that right to majority of the beneficiaries. They can remove a trustee if they need to or whatnot. And other times you can put in what's called a trust protector, a trust advisor. It's a person who can be appointed who will have certain powers given by the trust that allow them to come in and rewrite some provisions or remove some trustees that are bad actors, or even maybe be able to remove beneficiaries who aren't getting along too. So those are the steps that you want to have, in my opinion, that you want to have in a trust, is because that gives the flexibility for the inevitable changes of life that are going to come down the road, so that you can deal with those without decanting or destroying the whole trust.
So I want to wind this session down with kind of like a practical and tactical uh, way to assess where somebody might be as they're listening to this, and how to take action, right? So I'm going to say something, it may not be right. I'm trying to say it in a way that's super easy for people to remember as like a framework, right? So everyone's complexity is different. Some people have very simple, designs, and they're holding millions of dollars in one account and one name and the personal name. And there's absolutely, like it's like the equivalent of living in your neighborhood and never locking your door, right? And that's fine. No judgment. That's somebody's structure. Somebody else's structure is a couple of different things. Maybe a will that was recently done in the last couple of years, maybe a trust, and whatever, right? Maybe should be relooked at or hasn't been looked at in a while. Then there's someone who has multiple layers of LLCs and operating companies with a holdco structure, with a asset protection trust, with a private family trust company. And then there's like, okay, is this still accurate, or is this still encompassing because I just had all these other things happen, or I just got remarried, or whatever. Everyone's complexity is different, but everyone has the same problem, which is clear communication doesn't exist. Problems will occur, crisis will magnify, pain will ensue. So we all, regardless of our complexity, have the same concern. And so my question to you is, what's a simple who, what, where, when, how kind of framework for people to just assess what they should focus on first? Because if they have something to pass down and have something to lose, or have something that could cause pain for family members as a burden, and they're 50, 60, they don't have to be 80 yet. Who do I want to benefit? Why? What, what do I have in place already that's current or not? Right. So do I have a will? Yes or no? Is it up to date? Well, I don't know, but let's check, right? Like those kind of things. So what are the simple frameworks that someone should start with today, and just go, let me just give an assessment and figure out where I should start my conversations, and just knock a couple pins down to feel better.
Well, yeah, we think, the first thing that you need to figure out is, what is your estate plan? And some people watching today will say, "Well, I don't have an estate plan." Well, that's typically not true, because the state has one for you. It's determined by the statutes, and the reason why the state has that is they want to know where the property ends up and who's going to be paying for it. So there's some guidelines. So everyone has an estate plan. So at the very minimum, if you don't have anything written down, you don't have a written will, you don't have a trust or anything like that, let alone asset protection, irrevocable trust, you need to figure out, where's your stuff going? under the state law. Because if you don't like that, then you need to change it, right? But you kind of owe it to yourself and the people you love. Where's it going? And I've had people say, "Well, I'm single. I don't have any kids. It doesn't matter." Well, it does because it ends up going to your brothers and sisters, and if your brothers and sisters have like people on special needs, if they have people on Medicaid, those kind of things, and you leave them a certain amount of money just by statutes, you just blown their benefits. So it does matter, to your family, no matter how remote they are, it can matter to them, what they get. So that's the first thing is how's it going to go, and am I happy with that? The other thing is, do you have a champion in your corner? Do you have somebody who is going to figure this out? So you choose not to have a plan? Do you have somebody who's going to take this through the state so your property doesn't get lost in unclaimed properties and things like that? Do you have someone who's going to take over? And typically, we find with our single clients that they don't have these people, and we find that they're the ones that need a written plan more than others because they don't have anyone who really cares. And so, if no one really cares, your money never goes to where you want it to go. So those are the first things is just, I do have a plan. It could just be as simple as the statutory state plan, but you need to figure out what it is and what's going to happen to everything. And if you're good with that. If you're not good with that, then you need to maybe talk to an estate planning attorney and start changing what the state's going to do, either through a will or through a trust. Like we said before, a will or not having a will go through the probate process. If that's expensive, you want to avoid that. You'd rather have your money go to your beneficiaries than paying for probate. You need to talk to somebody to keep that from happening. As you move up there and you get some more wealth, you have kids. In my opinion, everyone needs a trust-based plan when you have kids because the kids may not be old enough to take the money, so you're going to have to leave it to them in trust. Or if you're going to leave it to them in a trust, why not start with a trust-based plan? But that's something we, talk to. It's just a personal decision of what you want to do. But you need to have some things in place. You need to have some people to protect your kids, keep them out of foster care, make decisions for them. Should something happen to mom and dad on date night and they're left at home with the babysitter. You just need to get some people like, and trust in place to make decisions when you can no longer make those decisions for yourself and for your family, for your minor children. So that's, typically a plan there. Now, when you start doing businesses and you have your sole businesses and things like that, we start talking about protecting your personal assets from your business assets. That's when a lot of attorneys will talk to you about developing an LLC system or some kind of holding company system structure where you can start taking things away from your personal side so that you're not as risk for something that you personally do compared to something that your business does. So that's kind of an evolution as well. And then when you get to the part where you get certain amounts of money that you want to leave to your children, uh, in an amount's big enough that they could start their life over with it. It might just be 250,000, might be 500,000, might be 20 million. But leave it to them so that their creditors, their spouses can't take it away from your kids. Then you're talking a little more about starting with an irrevocable trust for that kind of protection. And then if you want to do that for yourself, if you'd like to put part of your estate into a trust for yourself where my creditors and my spouses can't take it from me, that's when you're looking at those 17 to 19 states that allow you to do that asset protection stuff. So it's just in my opinion, you want a relationship with an attorney so that as you grow through your life and these things happen, you can kind of follow along and keep building your estate plan, your protection, if you will, as you go.
Yeah, I think that was a very good summary of the different um, ladder rungs that could exist. So depending on where you sit in that, call it $1 to $30 million investable asset or assets to protect and lose or pass down. Obviously, 30 plus, a billion plus. Same thing. There's more money, more problems. As Biggie Smalls said, um, more design. But I think for future ones, and you guys submit your questions, focus on some things you may have around kids and protecting them, especially under the age of 18, if something, God forbid, with their parents or you or your spouse, however you, or your domestic partner, however you organize and raise children. I think that's a whole hour long conversation itself. There's a lot of nuances, a lot of questions. I know I have my own that I'm actively in with that. And, the other side of it would be maybe we'll talk a little bit more about some of these more advanced structures and like generational skipping trusts and things like that as it relates to that personal Wyoming asset protection trust or related kind of structure for yourself, as well as asset protection trust for your beneficiaries. So maybe we'll do another one on that. If you guys want to hear more about those kind of topics, please, that's what the comments are for. Ask your questions. We'll weave them and consolidate them into a future Wednesday with Matt on Matt Chats. Let's see in the feed, a couple questions. If you have or heard something today that you definitely know you want to take some action on, and again, it's not related to litigation because that's not what Matt specializes in. If it's related to the preventative side and to the kind of the strategy and the architecture and the execution side of any of this stuff, if you're a Colorado resident, you can dial 970-820-0090. And if you are in any other state, you can dial 307-463-3600. And again, the specialty here to talk about will be those trust and will-based plans or the wealth-based plan, which is going to be kind of a mix of simplicity and complexity based on how much wealth you're managing and how much you're trying to pass down. So, Matt, any follow-up call questions that you had this week on your other travels with the workshops that you think are relevant to this discussion that you want to leave us with before we wrap up?
Uh, yeah, again, it's a lot of people need changes and they don't know where to go. So that's why sometimes it's good to have a relationship with an attorney and work with an attorney's office that wants to have a relationship with you. It's not just treating you as a number or a transaction when putting out a estate plan. That's probably not going to work 5 years from now. You just got to keep those up to date and things like that. And that's typically in my travels that what I've been seeing is how do we keep these things up to date? How do we make sure that they're going to work when we need them to? And that's also your financial plan as well. As if you're doing your finances, it's good to keep those up to date because you don't know where you are. You don't know what your ROI is unless you're looking at these numbers and things like that. If you're running a business, there's always numbers and you need the up to date numbers. So it's really a timely thing, even though it's only supposed to actually happen when someone passes away. For the
Mhm.
foundation trust, the revocable trust. The irrevocable trust, those are more of a strategy where you're putting things in ahead of time before you run into trouble, so that they can be protected when you run in trouble. Because no one ever wants you can't do anything after that incapacity event or after the creditor calls. I mean, after that happens and it's happening, now you're hiding money and the law does not like that. So it's just the proactive, I think, is the way, what I'd like to leave everyone with is just, make sure you're proactive. It's a lot less work, it's a lot less headache, and it's a lot more thoughtful and fun to talk about than when you're in crisis planning because something's happened and now you're trying to fix something. You just cause an accident on the highway. That we're way late in the game when that happens. So be proactive. Don't be scared to talk to an attorney. Don't be scared to talk to your parents. Always approach it that, hey, I'm trying to help things out. We're going to put some locks on your bank account, just like we want you to lock the front door at night. That's all we want to do. We don't want to take anything away from you. We just want to make it more safe. And I think that's the big thing. I always go back to communication, but I think in our society we're too much of individualists and we don't talk to each other quite enough.
Yeah, I think the other side of it is just without it being fear mongering because I'm not a guy who likes to do that. I think I'm an optimist at heart. I'm also a realist, and what I've learned the hard way too many times is the thing that happens to us that really usually sends us into that crisis mode, whatever you want to call that, is the thing that we would never consider doing to somebody else. Again, accidents and things like that aside, because obviously I don't think anybody goes and gets into an accident on purpose, but things happen. I'm talking about when we talk about predators and confiscation, the thing that we don't see coming is the thing we would never do to someone. So we don't think to prepare for it. And it's just practical and fiduciary to yourself to consider that there's a world out there that sees a massive transfer of wealth, which you and I've written about extensively, 124 trillion over the next 22 years. It's 5 trillion a year changing hands, regardless of what the markets do, regardless of what transferring from one ownership principle to someone else. And there will be leakage and there will be confiscation and there will be predators and scavengers and everything in between around that. And you won't see most of that coming, but you don't have to think about it or worry about it all the time. You just have to proactively think about what is your goal? What are you trying, who are you trying to leave it to? And what kind of mess are you not trying to leave them with? And then put in place whatever feels right to you. But I think that's the message we're trying to get across is you can't see it all. You won't know it all. None of us will, but you can at least take some proactive measures to sleep better at night and know that you're honoring your family and yourself in that way. So thanks for tuning in, everybody. Matt, as always, thanks for being here. We'll see you next Wednesday, guys. Look for the article and the replay in the drop. I'll be on Atomic Level Live tomorrow with Barry C. Knapp, talking about all things Ironside Macro with him. So if you are looking for something else to do tomorrow, tune in noon Eastern on a Atomic Level live stream. Matt, wonderful as well. I'll see you next Wednesday. And thanks for being here, everybody.
Thank you.